From Cypress Radio in Cypress, Texas, you've tuned in to the Special Ed Section 504 Radio Hour, and I'm your host, Louis Geigerman. Welcome back. This week, I have some guests that have been on the show before that I respect and call respect and what they do, and consider them friends of mine too, and colleagues, and I'm really glad to have them on. They're two attorneys up in the Arlington, Texas area. I've got Sean Pevsner, and I got Mark Whitburn of Whitburn Pevsner PLLC. Mark and Sean do quite a bit of, they do a lot of special ed cases. They also do other civil cases of various issues. And so they've been at it for a while, and we love to hear from them. And so the only thing about it, they're UT people, so we got to remember that OU rocks. But anyway, that's a thing particularly between Sean and me. And I thought I'd get a rise out of him. Anyway, welcome Mark Whitburn and Sean Pevsner to the Special Ed Section 504 Radio Hour.
Thanks very much, Lou. Thank you. Real pleasure to be here as always.
Yeah, of course. So let's talk about, one of the reasons I wanted to bring you guys on today. Now people are, this is recorded, who knows a couple of years from now where we're going to be regarding COVID and pandemics. I personally don't know that we're going to be out of this. I think we're going to be somewhere in some kind of morass that we'll be constantly dealing with some kind of issue for the foreseeable future, because we got so many anti-vaxxers out there. But anyway, what I wanted to talk about today is a problem that's really cropped up, because now kids are coming back to schools. Schools are opening up, as previously in the pandemic, a lot of schools weren't, and where they were in hybrid situation where kids would be going to school in person part of the time, and they would be virtually the other part of the time. Now, most of the schools are opened up, although if they find that there's that COVID's running rampant in their particular campus, they'll shut down that campus for a while in quarantine. So, but the problem that I'm seeing, that I'm particularly concerned about, that's come across my desk, and had a number of parents contact me about, is those individuals that are either immunocompromised, and so they can't really be, and they can't be those under presently at this recording, children under 12 cannot be vaccinated. Okay, so either those that are immunocompromised under the age of 12, or those that cannot be vaccinated for whatever reason, for other health reasons. What is a parent to do? Okay, what are the options that are happening here? Now, here in Texas, the schools are taking a position of one of two things. Number one, you come to school. Well, that's not going to work too well for those that are immunocompromised. Also, let's also look at kids too that cannot mask for other reasons, or can't keep a mask on because of their behavior or the issues relating to their disability. Schools here, what we've been finding is why have said, okay, we'll allow virtual instruction, but it's going to be parent-led. We'll give you information asynchronous, meaning they're just going to provide information like videos, et cetera, but not really having a live teacher work with the kids. So it's on the parents, or you come to school. So I want to talk about that with Mark and Sean, and talk about the legality of that, and how that applies to special ed law, ADA, and et cetera. So, Mark, Sean, I want, what are your thoughts about that?
Well, and I guess I'll start, and Sean can add his thoughts as well. But I certainly understand where parents are coming from in this situation. I know that Sean, of course, is over the age of 12. He's gotten vaccinated, et cetera, but he does not, in this age of COVID, he doesn't leave the house unless he has to. He wears a mask if he does, but the idea is, Sean has certain complications that are related to his disability, such that it wouldn't be a good idea to take any kind of risks with something like COVID. And certainly, if Sean were, younger and back, in the situation where he were faced with the decision of going to in-person classes or not, he certainly would not do that. And a lot of it is, uncertainty. We don't know what new variants are out there. We don't know, even with the variants that we have some knowledge of, we don't know exactly how they're going to affect various people. There's no sense in toying around with the life of your child. And I think a lot of parents feel that way and feel like, well, I'm going to protect my child first. I'm going to make sure that my child stays alive. And then, let's work with the school district to figure out what needs to happen to allow that, to allow me to make that choice on, for the health of my child. So I certainly understand where these parents are coming from. I think that's the kind of choice I would be making as well. And then the question is, if you're the school district, what are your obligations in the context of that kind of a decision? And I think that, the federal civil rights laws, the IDA in particular, makes it pretty clear that you can't just predetermine a one-size-fits-all approach to all these children, their parents who are making this kind of determination. You can't just say, well, come into school, or if you don't, you get this predetermined package that is going to be true of anybody who makes that choice. I don't think that works. Sean, what are your thoughts? I agree with you. Schools must provide homebound and no, I am in home services to people with people to students with disabilities because we are very vulnerable to catching COVID, and that may lead to death. I am DISABP disappointed with our government, with our government, with a disability E as F O or forfeited F O R V I forbidden schools to invoke, no, I M P impose mask mandates and P B V A C and vaccination mandates we need good, sorry, we need as schools that F O follow the science. So I noticed that Sean used the word homebound there in terms of that schools need to provide homebound instruction. I think part of what we're going to talk about today is that schools don't only need to do that. I mean, that homebound instruction might be something that schools might want to make available under certain circumstances, but even more broadly than that, for a lot of these kids, schools need to offer in-home instruction, which is a very different kind of thing. I know we're going to be talking about that a little bit later on.
Sure, absolutely, and I really do appreciate Sean's perspective too. I mean, Sean, you live it, so I mean that is really helpful. Yeah. So what what the schools have been primarily offering, like I said, are options of okay, some of them have been offering, okay, let's give you virtual instruction, but it's parent led. Actually, there was like a 3-week gap before they could start it, and then or homebound. Homebound to me is kind of a problematic term that apparently we're pigeonholed into using so often. Let's talk about, let's break it down, and at the end of the day, what schools have to provide. If you want to correct me on this, Mark or Sean. I mean, what schools have to do is they have to provide a free and appropriate public education, whatever that looks like. That's what they have to do. And so let's analyze these different elements. So let's talk about homebound and what federal law actually says about that. Would you like to talk about that, Mark?
Sure. Well, I mean, the IDA requires that a school district offer the least restrictive environment to in the provision of educational services and instruction. And interpreting the IDA, the implementing regulations say that there have to be a continuum of alternative placements that a school district has to consider in making that happen. And one of the possible placements that a school district should consider is in-home instruction. Now, a lot of times, school districts will assume that in-home instruction has to look like one particular kind of package that is outlined by the state's statutory code. For example, in Texas, we talk about homebound instruction that is defined in a certain way in the education code, but the two are not the same thing. Homebound instruction is really supposed to be a sort of a bridge. You know, you've got the determination on what this child needs, but then something comes up medically. And this doesn't even necessarily have to be somebody in special education or with a disability or anything else. This could be anybody, any student.
It's
But
like a kid breaks a leg or something.
Kid breaks a leg, it could be anything. But the person could be in special education, could be disabled, but or not. Something medically goes on with this kid, and so this kid is thrown off the educational track that he or she would otherwise have been on. So there has to be some sort of gap filler there. What are we going to do in the interim while in this very temporary period of time, while this is going on, so that we can bridge this child from what they were doing before in their educational program to what they're going to do after this very temporary period is over. Now, the IDEA doesn't really speak to that issue in terms of what do you do in when you need some sort of medical bridge. That's not really what this continuum of alternative placements is designed to discuss, because that's not really a change in placement. That's just how do you stay in the same placement and just sort of bridge the period of time where you can't take advantage of everything going on there, right? But when you're talking about a situation like we're talking about now, where you've got all of these uncertainties, you've got children that may be staying home for an entire year. You don't know how long this is going to last. You don't know exactly what the potential effects on these children are going to be. All of a sudden, you're not talking about a bridge, a temporary bridge anymore. You're talking about, how are we going to provide educational services to this child that really constitute free and appropriate public education? Now you're starting to talk more in placement terms. You're talking about, how are we going to envision a set of circumstances, both location and otherwise, for this child that work with current circumstances that allow us as a school district to provide the educational services and instruction that's required under the Individual Disabilities Education Act. You're not talking about a bridge anymore. You're talking about how are we going to get this done for this child? And there's a whole lot of considerations that come into play with that. Many children, whether they're in special education or not, have got to have some level of exposure to their peers, because if they don't, they're not going to get things that are absolutely critical to their educational performance later on. They've got to be able to see what their typically developing peers are doing, how they interact socially, how they approach their academic work, how they approach adults. You want to see how your typically developing peers are interacting with the teachers. You want to have an opportunity to interact with themselves. The kind of options you talked about before, asynchronous, virtual instruction, parent-led, or purely homebound instruction where you're not interacting with your peers at all, that's not going to get that done. And we talked about sort of the IDA and its implementing regulations, and the fact that the IDEA and the implementing regulations don't really speak to just this issue of a temporary bridge based on temporary medical circumstances. But the IDEA and the implementing regulations certainly do speak to the kind of thing we're talking about now, where a child is in a situation where it's no longer a temporary, very temporary bridge. It's a full-blown situation that could last indefinitely, where this child, may be risking death to go into the school and has got to have the array of services and instruction provided in the home in order to obtain a free, appropriate public education. Under those circumstances, the IDEA does speak to it. And where the IDEA does speak to it, state law has got to be secondary. State law is preempted, and school districts have got to observe the dictates of federal law.
Now, one of the things that is I see as problematic on that is we look at, I shared with you, Texas state law regarding homebound instruction, which basically says, and as to your point, homebound was really more of a general ed placement, but somehow it's been adopted as the end all and be all if you're at home, okay, versus instruction in the home or services zone. One of the requirements under homebound is that a physician needs to be part of the team because they have to sign off on this document. And the document, the homebound form, basically stipulates that it has to be a condition, a medical condition that renders a student unable to attend school for a period of 4 weeks, not necessarily continuous. Now, where are the problems with that? Number one, I don't know of anywhere an idea that a physician needs to be part of the team. Now, having said that, I mean, certainly a physician can weigh in and provide documentation or letters about a child's particular situation, even if they had another health impairment. That would make sense for a physician to do that. But to basically mandate that a doctor sign off, and they actually have to do that also on other health impairment when I think about it. But to mandate that a physician's part of the team, I find that somewhat problematic myself, because it's still the ARD committee, the IEP team that should be making those determinations. But couple of major issues I have with it is that, okay, it has to be a condition that it's a period of 4 weeks, not necessarily continuous. That's a long time for them to mandate that. I shared with you like Connecticut's statute where it's like 10 days, 10 school days. That's a difference from 4 weeks. And again, though, I still think a definition is important because, there are a number of reasons that a student cannot be at school, but to mandate a physician has to sign off on it, to mandate. And the other problem is, we find a lot, is that they only provide core instruction only in the core courses for homebound versus instruction or services in the home. I mean, it's a way by which I see, and the other problematic problem with it is that what the state says equals, I'm looking at Texas now, they give a table on what equals a full week of instruction. And according to their funding mechanism, 4 hours a week equals 1 week of instruction. 4 hours equals 1 week. Now, it says also that it gives different numbers about they could do more than 4 hours. But when the schools look at this, they say, oh, 4 hours equal a week. That's all we're going to do. And invariably, that's not sufficient for a child. So, I mean, you want to talk about that? I mean, I find it so restrictive, and at the same time, the real question is that really providing FAPE?
No, I mean, certainly I wouldn't want to make generalizations to say that there is no child, hypothetical or otherwise, out there for whom that could ever provide FAPE. But I will certainly say this, that it is impossible to take that formula and predetermine that for every child in this set of circumstances that it automatically does provide FAPE. And so by doing that, because these determinations are generally not individualized and tailored to the unique characteristics and circumstances of the particular children we're talking about, you know from the outset that this is not calculated to provide faith, because they're not really, a lot of these school districts are just taking this stark choice. No matter who you are, you either come in or you're going to accept this particular state-defined set of services, and that can't be right. That can't be right. There's got to be, every child has to be evaluated based on his or her own set of circumstances. And especially in this, when we're talking about COVID, when we're talking about, well, you need a physician input on all this, that if we're talking about a kid that comes down with an advanced state of chickenpox or something like that, there's a pretty solid body of knowledge as exactly what that's going to do, how long is that going to last, what effect is that going to have on a particular child, everything like that. But physicians differ dramatically on how COVID is going to affect children, how COVID is going to affect adults. There is a very wide array of opinions on exactly how this is all going to play out generally, and certainly how it's all going to play out with respect to any individual child. So I think here, the process has got to be less dependent on what some individual physician says is likely going to happen, because physicians right now are sort of flailing around pretty blindly too in a lot of circumstances. The decision here, I think, has to be largely based on a parent's decision. Look, I'm not, regardless of what some individual physician says, there's too much uncertainty. I'm not going to allow my child to roll the dice, or I'm not going to allow the school district to roll the dice with my child. How are we going to accomplish a free, appropriate public education if I make the decision that my child is not going to have his or her life risked? I think the IDEA would say, you need to take a look at the circumstances of that child and provide an array of services that is calculated to provide free and appropriate public education, just as you would in any other set of circumstances. And if that has to be in the home, that has to be in the home. That's just the way it is. You can't say, well, this person, because that parent made the choice that the life of the child's not going to be risked, 4 hours, that's what you get automatically. We need a physician to do X, Y, and Z. It doesn't work like that. The IDA doesn't work like that.
Well, and Sean, I'm gonna want get your input, but the other thing that I think is important that we're kind of skirting is the least restrictive environment issue, and providing services to the kid, and that's where I think virtual instruction can help bridge that. But Sean, Mark and I have been doing a dialogue here. I want to be sure I get your input.
V. Virtual instruction is a great thing. It allows students with disabilities to participate in class and interact with their peers without disabilities.
I'm sorry, Jess, I didn't mean to interrupt you, Sean.
Technology and technology has advanced. significantly to IMPO to improve the lives of people with disabilities and include, sorry, and STSC and schools should should embrace the technology to help their students.
Oh, I can't agree with you more. In fact, frankly, if there's anybody that can speak affirmatively, authoritatively on assistive technology, it's you, Sean. So, I mean, really, at its importance. The thing about that we've found in COVID is things that the school said for many years we can't do, we find that we can do. My big problem is, when we do home, when you give a stark contrast, only two options of homebound versus, really being in class or even that parent-led deal. The problem is something that it's huge and something that's missing when somebody has homebound, and that is the one issue that's missing in homebound is you're not getting the dialogue with your peers. You're not able to have classroom discussions when you're dealing in a homebound situation. Now, I understand some of the schools' reluctance on this. I mean, which is, I can tell you, it's very. I mean, if either the rest were put in this situation, it would be difficult in that for a parent to do, excuse me, for a teacher to both be managing the classroom, his or her classroom, and at the same time providing virtual instruction. I mean, it's kind of difficult. It's like, well, for those of us that remember the Ed Sullivan Show, it's like the guy that had all those plates and spinning on poles at the same time. But I can understand that being a challenge. I certainly believe they would have to hire more staff, to make that happen. But doggone it, we need to find a way that can do that, to be able to have non-disabled peers and classroom discussions happen when children are being met at home. I mean, are getting instructed at home. But I think one of the things that really I didn't really hammer home here is to parents. If they're saying to you it's homebound or school, as we were trying to explain, it's federal law doesn't say anything about homebound. That's a placement that various states have and make various requirements. All it says in federal law is, a set of a continuum of alternative placements, which includes instruction at home. So, what I tell parents to say is that if you're looking for help at home, is that you're asking for instruction and services in the home, but I'd like it virtual, thank you. I'd like to have virtual for these students, virtual instruction in the home and services in the home in those type of situations. But I would never go out and give the term homebound. I think homebound becomes far more restrictive and really has different set of guidelines that the states have set forth. Do you want to weigh in on that, Mark? Sean?
Yeah, I mean, I certainly agree with you. I mean, I don't think homebound, as you know, certainly the way that it's used in Texas law, I don't think homebound was ever designed to be a placement decision at all. I think homebound, you know, as we were talking about before, was more of a, you know, okay, this child's in a placement that if it's in a special education context, we've made a determination about this child's placement. This child is receiving FAPE in this placement, but then needs a temporary bridge, and we're going to use that homebound. But that's not a change in placement. That's just a way to get to the other side of this temporary medical issue. In terms of placements, like we were saying, I mean, I think it's 34 CFR 300.15 that the implementing regulation for the IDA specifically references a continuum of alternative placements. Well, two options does not make a continuum, right? A continuum is a full spectrum of possible choices that make sense in the context of that individual child's education. So even if you know that this child has to be educated in the home, that only starts the inquiry. You can't just say, okay, now we know this child has to receive services in the home, so that's going to be homebound as defined by the Texas Education Code. No, if you break up a continuum, you've still got a continuum. There's a continuum of possible ways to conduct in-home instruction as well. You still have to examine a whole host of different possibilities to determine what's right for this child. And as you say, that may very well be in a lot of cases would be synchronous virtual instruction, because a lot of children, I would say most children, the vast majority of children, are going to need exposure to typically developing peers or their peers, and however you want to define that, for all the host of reasons that we talked about before. And there has to be a way of providing in-home instruction that accommodates that. Otherwise, you're not providing a continuum of possible alternatives. You're just from the start violating the IDA and its implementing regulations. So yeah, I'm in full agreement with you.
Yeah, it's interesting. I was on some listservs or some Facebook, and one person said to me, was very, very adamant, and they said, well, the schools don't do it so well with virtual. Go to there are public virtual schools that you can go to. And I said, okay, that's well and good. But number one, you've taken your local school district off the hook for them providing FAPE, and that's not right. And then number two, I think this one particular virtual, and it was a virtual public school. This particular virtual public school, though, while they had a campus, they had I don't think the word is campus I want to use, but they had one of their group, one of their, the parts of their instruction was in the same locale. We're here in Houston. So let's say they have one locale in Houston. Houston's a big area. I mean, it's like the fourth largest city in the country. And so what are the chances of you ever having peers of non-disabled peers that you would ever get together with? Let's say Houston's, between parts of Houston, you could travel 50 miles, between go to Galveston, I'm just saying, those kids up in the Woodlands, is somebody in the south part of town, are they going to be hanging with those kids?
Right.
Probably not. So what I'm saying is, I said that that's not really a viable alternative. You want something, an opportunity. One of the mandates of least restrictive environment is to be in your neighborhood school. You know, those are kids that you're going to be ultimately be hang, you know, those are the most highest propensity of you having relationships with, get to know kids, and they maybe they end up being lifelong friends. But you know, saying that, oh, well, we have a Houston campus, that doesn't boil down to where you live. That's not LRE in my view. I mean, what do you think about that?
That is segregating students with disabilities. That is SE separate SCP A separate but equal. That is unlawful and improper. No, you, no, I am immoral.
Oh, I can't agree with you more. I mean, it absolutely smacks of Plessy versus Ferguson. Abso-freaking-lutely. I think what really, you know, we talk so much about IDEA on this show, but this is really, as you know, as I believe, I think this becomes really an even bigger issue of Section 504 or the Americans with Disabilities Act. You know, you want to address that, Mark?
Well, I certainly agree with that. I mean, I think is if you are, you know, and not just that aspect of it, but this whole issue of predetermining that really, you know, unless students with disabilities are going to come physically into the classroom, that they get really the most restrictive spot on the continuum that they could be placed, is discriminatory in my mind. It's certainly to say that that, you know, people that students with disabilities who are receiving special education are going to be consigned to a situation where they have to turn away from their own school district to receive the kinds of instruction of a public virtual school like you're talking about. Yeah, I mean, that's, you can't just carve out students with disabilities to receive the short end of the stick, to put it in colloquial terms, and a short end of the stick that is not going to be designed to further their educational progression. I'll say too, you know, about this idea of you know, not having the same interaction with peers that you'd ever meet, or this sort of thing. You know, I think it even goes beyond that too. I mean, if when the schools were closed and everybody was receiving education virtually, then, you know, you can you know, the kind of interaction between peers that you're going to be a part of, if you are at all, is, you know, some sort of virtual interaction. But it's a little bit different now because a lot of these typically developing peers are in the classroom. They're there physically. So it's a different thing to be forced into an environment where everybody's interacting with each other virtually, versus an environment where a lot of what you're seeing is people interacting with each other the same way that they always would in an in-person environment. Yes, you're seeing that virtually, you're interacting virtually, but a lot of the dynamic is defined in the way that it normally would even without COVID, because a lot of these kids are in the in-person environment. So, you know, it's a different thing to observe the dynamic of human interaction, or the interaction of children as they're bouncing things off one another in a real-time in-person environment, than to have everybody be in a virtual environment, to be forced by your school district into that situation.
Sean, do you have any additional thoughts about that?
No.
Okay, so what I'm, the tact I've been going is I've been taking is I've been saying, parents, look, they say, well, what do we, they're asking me, what do you do, Lewis? And I say, well, my view is that you got to go to your you got to go to your IEP teams and say, hey, I need virtual instruction, and I need virtual instruction. I need my instruction to be services instruction in the home, and I want that to be provided to me virtually, and see where and see where the districts go on that. Now, if in those IEP meetings they say no, I would bring up issues about least restrictive environment. And if they're trying to pigeonhole you into a scenario like, well, you can do the parent-led deal or or homebound, I would start making issues about, hey, I don't think that's providing an LRE for my kid. I also think that there are issues regarding ADA, the Americans with Disabilities Act, and Section 504, because that's impacting my very access to that instruction. And see what the committee will do. If they say no, well, then there are options. What do you think about that in asserting your rights?
Well, I think that's exactly right. I mean, I think it's very important to not just talk in abstractions in these meetings. It's very important to really lay it out there in the course of an ARD meeting or any other kind of interactions that you have with school administrators.
When we use the term, just for the record, folks, when we use the term ARD, that's an IEP meeting everywhere else in the country. Okay, so sorry, Mark. Go ahead.
So when you're in the context of one of these meetings, you don't want to just talk in terms of abstractions. You don't want to just say, cite a regulation and say, well, I don't think that you're, providing a full continuum of alternative placements or something like that. As a parent, you're the one who knows your child best, and you've got, presumably you've got information about your child, whether in the form of full individual evaluations. You've got all kinds of documentation on your child. You can point to the reasons why your child needs something more than what is, at least in Texas, defined as homebound instruction. You can explain, look, here are all the things that we talked about in past years about what my child needs. My child didn't all of a sudden stop needing these things because of COVID. My child still has to be on a certain educational trajectory to move forward. In some cases that we've heard, a child hasn't been able to interact with peers as much as 18 months. Explain to your school district, how long has it been? What is my child's situation? How is this affecting my child? How would it affect my child, whom I know better than anyone else in the world? How would it affect my child to have to go through this for as long as you're telling me this might take? That's not going to provide my child with a free, appropriate public education. At this stage of the game, I think that you're absolutely right. You want to say things like, I think this is a violation of the ADA. I think this is discrimination, but you want to fill in those gaps with, stressing this particular information about your child. My child needs this. My child needs interaction with peers. My child is going to regress socially, regress academically without that kind of interaction. You got to provide it, because otherwise, she or he is not going to get the educational tools and not going to be able to move forward in the way that we've talked about every year before COVID. We need to still be talking that same way now.
Well, I make it what I tell parents is, I said, I think it's best to not use the term homebound, and use the term homebound. And when you're asking for assistance, and the districts will keep hammering. Part of the problem I noticed on homebound is that while we had a district that actually agreed with us, they said, well, on the paperwork, we're going to have it homebound because we can't get funding from the state unless we call it homebound. In other words, they said that if you call it instruction home or service in the home, the state won't fund it. Now that's a problem, I think. Okay, I think that's a super problem that needs to get fixed in the courts or other places. But that's a real problem. They can't do that, and I think I know of a particular case, an attorney that I'm acting as a paralegal with has included the state education agency as an additional respondent for that very reason, because they're culpable for making those regulations. And I think that really handcuffs school districts or our IEP teams to actually do what they're supposed to do, for the benefit of the child. That's just a sidebar comment. But what I'm telling parents to do is just say, hey, I want instruction and services in the home, and I want it virtually, and see where for the reasons that you said, Mark, and see what the answer is. And if they say no, what should the parents do, Mark?
Well, if they say no, despite the fact that I am an attorney, I don't tend to cultivate litigiousness. Nonetheless, in these sets of circumstances where if a school district is refusing to provide the services in the home in a way other than the very limited manner in which the homebound is defined under Texas state law, I think as a parent, you've got to take that to the next level. You can't let them do that because these are critical years for almost any child. You can't let years go by where integral components of that child's education are being lost. You've got to do something about it. I know that can be difficult. I know that can be stressful, but as a concrete answer under these sets of circumstances, I think you pretty much have to do it. And that is get in there and file a due process claim against the school district and insist that the dictates of the Individuals with Disabilities Education Act and the implementing regulations be followed.
Yeah, and I tend to agree with that. I mean, okay, a parent could file a written complaint. The problem with a written complaint is they have 60 days to the state education agency has 60 days to respond in make a decision on it. But the problem is, if it got down to brass tacks and there wasn't there wasn't they don't have a hearing, so you've got a fact finder that's going to have to look through documentation and determine where they are. I think and something like that, I think you actually need to have people, if it needed to be, I think you actually need to have people testify under oath of what the impacts are to a student. And that would include parents and, of course, any expert witnesses that need to come forth to talk about it. So I don't know that a written complaint really gets it done as much as as a due process complaint would be. The other thing would be, okay, somebody could file with the Office of Civil Rights, because I think there are some discrimination issues regarding this for sure, The only problem with OCR, it takes too much time. It takes a month of Sundays, and again, you got the same problem of a fact finder versus somebody on the stand actually talking about the needs under oath. So that's one issue why I think parents should be filing DP, whether they do it pro se or otherwise. But the other part is there needs to be at some point at some level there needs to be definite. I still think there needs to be a definition at the at least in this state and maybe some other states of really making clear that there is I don't know if I would use the term decoupling, but a distinction between homebound services and instruction and home and services in the home, and they are different. And I don't see that fortunately, every time you talk to a school district, they keep saying, "No, you mean homebound." I said, "No, we mean instruction and services in the home."
Right.
And it's something that needs to be at some place where there's got to be a judge that needs to hear that and make a distinction so that the discriminatory, I think it's discriminatory funding practices if they say that's the only way the state will fund it. I think those are things that need to be looked at, from a bigger picture. I mean, it's about the student, number one, but in a bigger picture of handcuffing the school systems and making and the IEP teams, I think that's a huge problem. I think that's something ultimately probably should be considered to be litigated. I'm not an attorney, but that's just my view, just a layperson's view. Anybody's thought about that?
I agree.
I appreciate that.
Yeah, I know. I agree also. I mean, if you're filing a written complaint with the TEA, I mean, as you said, the Texas Education Agency is partially implicated in the problem here. So filing a written complaint with the Texas Education Agency itself, apart from using up time, is not necessarily going to get you where you want to go. The advantage of filing a due process complaint is that it then provides you an avenue, even if you get a hearing officer that is not particularly sympathetic to your position or perhaps does not feel capable of making a ruling predicated on some of the nuances we've been discussing. That gives you your avenue to get past that into a venue like federal court, where you can have a court that is not sort of tied in with the Texas Education Agency pronouncing on these kinds of issues.
Well, it's not just that. Oh, I'm sorry, Sean. I didn't mean to interrupt.
The TEA should not have any power over the hearing officer. They should obey, do, they do it could no it see a causes a conflict of interest in some cases.
Yeah, I totally agree with that. Sean. We're actually at the end here. So the last thing that I would say about that too, DP, we know that at least in 15 calendar days, if you file for due process, at least in 15 calendar days, there would have to be a meeting with the school and with the parent to potentially resolve those issues. You don't have that in other venues, and that's another reason. So that kind of makes sense to me. Well, guys, like it usual, it's always a pleasure to have you on. Mark, Sean, if somebody wanted to get a hold of you guys or contact y'all, what's the best way to do that, Mark?
Well, I think probably the best way to contact us is through just calling our office line. Our number here is 817-653-4547.
Say that again for us, please.
Sure, it's 817-653-4547.
And you also take cases out of state too, I believe. So depending on the scenario.
We do. Or you can go to our website.
And what's that website?
The website is www.whitburnpevsner.com.
www.whitburnpevsner.com. Well, listen, guys, I really appreciate your input always. We need to do this periodically, and I think we will continue to do that because I love your guys' perspective. I'm Louis Geiger with National Art IEP Advocates. We have an advocacy firm that basically we're based out of Houston, but we go all over the state, and we also do out of state too. If you need to contact me, my website is narda.org. My email address is nationalardadvocates, plural, @gmail.com. That's nationalardadvocates nationalardadvocates@gmail.com. Website narda.org. If you want to contact me about the show, go to SPED Radio, SPED Radio 103.5 @gmail.com. SPED Radio at 103 SPED Radio 103.5 @gmail.com. Also, you can tweet me at LOUISNARDA at LOUISNARDA. This show is brought to you by cypressradio.org, which operates by donation. So it's nonprofit. So you go to cypressradio.org and make any contribution you like. Archives, I am building archives on my YouTube channel at SPED Radio. Just go to SPED Radio on YouTube and subscribe. I'm building that as time goes on. If you need to contact me to get a specific show that's not up there, I'll share it, but it may not be edited. But don't worry, there won't be any 4-letter words that aren't edited. Anyway, I want to thank Sean and Mark for coming on the show once again. Y'all are great, and we'll do it again. And so for all my listeners, I'll see you on the radio and the internet. Have a great week.